Okay, so some brief history here. For the past 3 years, I was renting what is referred to as an auxiliary dwelling unit. An auxiliary dwelling unit is a smaller, detached, independent residential dwelling unit located on the same lot as a standalone single-family home. It's sometimes referred to as a mother-in-law's suite. In my case, it was a pool house that was converted into a living space by adding a full bathroom. It was small, it had no kitchen, but I'm a single guy who eats out most of the time. I'm rarely at home except to shower and sleep, so for me, it was an inexpensive option for someone who lives in California's extremely expensive rental market. For me, it was perfect, except for the fact that it was only equipped with a small space heater that I found to be both inadequate to heat the unit in the coldest months and dangerous to leave on unattended or while I was sleeping. So after my first winter there, my landlord had promised to install a heating unit, but never had. And with my third winter quickly approaching and no relief in sight, I decided to call the city building inspector's office to find out what my options were. I wish that I had remained anonymous on my phone call because what followed was a nightmare. After my call, the city apparently did some investigating into the property and found out the unit was built without obtaining permits from the city. And 2 days later, building inspectors came knocking on my door at 8 a.m. They informed me that the unit was being red tagged and gave me 10 minutes to gather what I needed before I'd be locked out and no one allowed to enter the building again, or they would be subject to arrest for trespassing. And just like that, I had no home. I had no access to just about everything I owned. I had just paid my rent the night before, so I had only about $150 until I got paid again. So I gathered my stuff in shock and put it in my car and drove off, not knowing where I was going. So I got on the phone with the city and was passed from one person to another, pleading my case until they finally agreed to allow me to return to my home for the next 2 weeks, but only to gather my property and only during daylight hours, which is 8 a.m. to 5 p.m. about this time of year, the hours most people are working. So at a time that I needed every penny to afford to rent a new place to live, I was going to be forced to take off work just to get my stuff out of there. I was completely in shock that this was happening or that it was even legal. Thankfully, I didn't have any small children that lived with me. I remember thinking there should be a law that protects people in this situation from being forced out in the street with nowhere to go. I mean, it's ludicrous. Well, it turns out there is, and the city is required by law to inform the parties involved. But the city knew nothing about it. And these are the videos of me dealing with the city over this. So this is me heading down to the city to pick up this letter that they're going to give me, granting me access to gather my property. And I want to show you this to point out that I am everything short of pleading with this woman to tell me about anything that can be done to help me out because I'm screwed basically. So watch this.
Hello.
Hello.
All right, so what I have here, this is the permission to enter. So this will be good for 2 weeks.
Okay.
During daylight. Make sure your name is correct.
Okay.
So basically this is letting the police department know, because the red tag was placed on the building, that it's safe for you to enter for the purposes of grabbing your things, personal belongings. 2 weeks we feel is sufficient to be able to get all of your personal belongings out. However, for whatever reason, if there is an issue and you need a little bit more time, we're more than willing to discuss that with you at the time on a case-by-case basis, so to speak. So that'll be yours. And then This here's what I was referring to, kind of the resource sheet. So there's some information on here that might be helpful to you as far as contacting someone to answer some questions about landlord-tenant disputes. Hold on just a second. I want to make sure, because where it's at on here, housing. Here we go.
Okay.
There's some housing ones here, and I actually might print you out another one. It says parenting on it, but it also does have some information. Oh, here we go. This is it right here. This is what I was looking for. So Echo Housing,
Okay.
different places that can at least guide you.
So you guys don't have the tenant landlord handbook?
I don't.
Okay.
I don't.
Okay, let's get it printed out.
Yeah, but I think that those places will at least be able to maybe email it to you, or
Right.
offer you some assistance as far as answering questions on what your rights are and how to work that out. We'll work with the property owner, our building department, as far as getting the violations remedied. But as far as living in it at this time, unfortunately, you wouldn't be able to do that. So.
Right. So where does it says 2 weeks or something on here?
Yeah, so it's valid from today, November 1st, 2021 to November 15th, 2021.
Okay.
During daylight hours, so whatever time that ends,
Now
5
what
o'clock.
determines the 2 weeks?
It's based on
Is
the
that-
size of the structure, it's based on the circumstances, it's all kind of varies depending on the circumstances. But we feel it's 2 weeks should be sufficient for you to be able to, remove your belongings.
Because it was my understanding that my lease is still in effect.
Well, your lease is in regards to your living there, but you're no longer living there because
Right.
we've red tagged it, so
Right.
you can't live there.
But I can leave my stuff there.
You can, so
Right.
for whatever but you also, if you were coming, so say for example, in 2 weeks, you said, I haven't moved out anything, well, that's gonna be a different story because we've given you 2 weeks to move it out and you haven't done any.
Hold on. That would be a different story? But didn't you just say?
2 weeks, we feel is sufficient to be able to get all of your personal belongings out. However, for whatever reason, if there is an issue, and you need a little bit more time, we're more than willing to discuss that with you at the time on a case-by-case basis, so to speak.
I have no place to take it. I'm
Yeah.
just now looking for someplace.
Right, and so if you're in that situation, that's why I say
I'm
give
in
us a
that
call.
situation.
Well, I'm saying in 2 weeks,
Okay.
give us a call, say, look, I haven't been able to find a place to move my stuff. And so
Right.
I'm gonna need a little bit more time to be able to go back over there. So if you say within a week, I should be good, I have secured a place, it's gonna take me another week, we're more than happy to give you that time to do that.
Well,
It's just,
I wanted the remainder of my lease.
yeah,
done.
unfortunately, we can't do that, so,
My lease is still
but I
legal.
mean, our basis is not based on your lease. Cause as far as
Right.
we're concerned, the lease is irrelevant because it's not fit to live there.
But
So we're not
what I
working
read
within the
is
restraints of
that
the lease.
this won't override my lease. My lease will still be good.
I'm not sure about that, cause that's more on the legal side, that's why we
Right.
always tell people to contact someone that would be able to clarify what your legal rights are as far as the terms of your lease, cause that would be something out of our realm, because we're not dealing with the landlord tenant side of it.
Right.
We're dealing with the safety building side of it.
Right.
So as far as the safety of the building and the building, the building permit and all of the things that are related to that, that's what we're concerned with. So,
Right.
as far as giving you 60 days, unfortunately, I can't give you 60 days to take your things out. But again, in 2 weeks,
Wait a minute.
we'll
though,
revisit it.
Because what I read is that this doesn't affect my lease whatsoever. It affects me entering the building.
for the purposes of taking your belongings.
Right, but
Specifically, so if you're there and you're there during the day and you're not removing your items, that's a different story.
no, I've actually got a place
Yeah.
that I'm gonna stay and sleep.
Okay,
I just can't bring any of my stuff with me.
right.
And so I was under the understanding that I have 2 months left.
Yeah, that part I can't answer because unfortunately, that's just not in my realm of understanding.
It was at this moment that I realized this woman doesn't know anything about the law surrounding this situation. that in 20 minutes of searching on the internet, I knew more than she did. And she was basing her 2-week time limit that she was imposing on me on her feelings alone and not on law.
And how the lease works, and we just unfortunately are not in a position to give legal advice on how to handle it. So that's why, that those people on that list would be a good resource.
Okay.
To contact and just really confirm that, because I honestly don't know.
Right.
And I'd hate to give you wrong
No,
information.
I did a lot of reading, so
Okay,
that's the way I understand it. Is that
okay,
for the term of my lease, I can leave my property.
okay. Well, now the situation's changed. You have a red tag on the property. You have a permission to enter. I would maybe just revisit that and let them know that this is where you're at right now, and maybe they can give you guidance based on your current
Okay.
circumstances, okay?
Okay, great.
All right.
Thank
And
you so
have
much.
our number, right?
Yes.
Do you want my card?
Sure.
Okay. So if you have any questions, concerns, definitely just call us.
Okay.
All
Thank you
right?
much.
All right, take care. Thank
You
you.
too.
So basically, I was pretty much on my own, and I spent the next 3 or 4 days digging and digging, and that's when I came across this. Back in 2004, Section 17975 was added to the California Health and Safety Code, and it states that any tenant who is displaced or subject to displacement from a residential rental unit as a result of an order to vacate or an order requiring the vacation of a residential unit by a local enforcement agency as a result of a violation so extensive and of such a nature that the immediate health and safety of the residents is endangered, shall be entitled to receive relocation benefits from the owner as specified in this article. The local enforcement agency shall determine the eligibility of tenants for benefits pursuant to this article. So basically what this is saying is that if your property that you're renting is red tagged, and there's a couple stipulations. One is that you, as the tenant, did not cause the red tagging of the property, and another was that there wasn't a flood or an act of God, basically, that caused the red tagging of the property, that the property owner is required by law to pay you relocation benefits. And Section 17975.1, Part A, reads, the relocation benefits required by this article shall be paid by the owner or designated agent to the tenant within 10 days after the date that the order to vacate is first mailed to the owner and posted on the premises, or at least 20 days prior to the vacation date set forth in the order to vacate, whichever occurs later. 17975.1b states if there are fewer than 10 days between the first posting and mailing of the order to vacate and the vacation date, the relocation benefits shall be paid by the owner or designated agent to the tenant within 24 hours after the notice is posted and mailed. The local enforcement agency shall attempt to provide telephonic or written notice to the owner to notify the owner that the benefits are payable immediately. Failure to provide the notice as specified in this section shall not relieve the owner of any obligations imposed by this article. So basically, they were to inform my landlord that she had 24 hours to pay me these benefits. Section 17975.1c reads, if a tenant is entitled to relocation benefits pursuant to Section 17975, the local enforcement agency shall provide either telephonic or written notice to the tenant of his or her entitlement to the benefits. Written notice may be satisfied by posting a written notice on the premises stating that the tenants may be entitled to relocation benefits. There are also a couple of other benefits outlined in this article that are pretty lengthy in the wording, so I won't go through reading them, but basically that provide an amount intended to cover any deposits that the tenant would have to pay for utilities in the new home that he finds, and as well as a full refund of any security deposits that he paid on the property that he was displaced from. In another very, very wordy section of the article, it states that the amount of relocation benefit payment shall be determined by the Department of Housing and Urban Development pursuant to the area that the displacement occurred, and that the local enforcement agency was to determine that amount and report it to both the tenant and the landlord. Just remember that, because that's a big deal later on. And finally, section 179.75.8 reads, any order by a local agency that requires a tenant's displacement and is issued to an owner, designated agent, or tenant shall be accompanied by a summary of the provisions of this article. Failure to provide a summary shall not relieve any person of the obligations imposed by this article. Now, to me, that's pretty cut and dry. I mean, that pretty much spells out that the local agency has to notify you of this law. But they didn't seem to see it that way. Watch.
Hi, I need to speak to Michael Emery or Jody Williams. Michael Emery or Jody Williams?
Yeah, Jody is here. Mike is out doing inspections, but I could go ahead and let her know.
Okay.
What was your name?
Thank you.
Hi, good morning.
You remember me?
Yes.
Okay. I did some digging and came up with California Health and Safety Code 17975. Are you familiar with that? Basically, it's written for my situation, that any tenant who is displaced or subject to displacement from a residential rental unit as a result of an order to evacuate, an order requiring the vacation of a residential unit, glass is fogging up, by a local enforcement agency as a result of violations so extensive such that the immediate health and safety of the residents is endangered, shall be entitled to receive relocation benefits from the owner as specified in the article.
Yeah, so have you spoke to your owner?
Well, the thing is, you guys were supposed to tell her that. You're required by law to...
Well, was she
Wait,
been told that she's required to do
let me
that?
finish. You're required by law to inform her and to inform me. You guys did neither.
We're required by law to inform you of what?
That of this law. That she has to, you're supposed to determine the amount.
No,
Yeah.
no.
Well,
What, she's
read
the
along with
owner,
me.
sir. She's your landlord. she's required to provide you relocation. If she does not do that, that's a civil matter between your landlord and you.
Right, but you're required to inform her of that.
Well, we haven't told her that.
You didn't tell me anything. And you're also...
Well, I told her and I told you that it's a landlord-tenant dispute and that to contact, we are not allowed to give legal advice.
Right.
We basically say, we're focused on the safety of we're focused on the structure.
Right, but 17975B requires you to inform her that she has to pay within...
Well, the thing about,
10 days in my
it's a
circumstance.
civil matter. We've told her that it's a civil matter. The only thing that we're working with her as far as is remedying is the not being able to be lived in and getting the things in there that need to be permitted so that it's no
Right.
longer a red tag.
But-
So we've told her that as a landlord, she has obligations to her tenant. Whether or not she fulfills those obligations, unfortunately, we can't enforce that. That's a landlord-tenant matter.
Well, no, it's not about enforcing it,
Mhm.
it's about informing her.
She's been informed of that. We told her that when
So
we
what
spoke to her.
what is the amount that you told her?
Oh, I don't tell her the amount because that's not to be determined by us.
It is, actually.
No,
Hold
sir,
on,
it is
let me
not.
read it to you.
Okay, I understand that, but that's something that you would need to, I would
170
strongly advise you to hire counsel.
17975.2 reads, the relocation payment shall be made available by the owner or designated agent to the tenant in each residential unit and shall be a sum equal to 2 months of the established fair market rent for the area as determined by the Department of Housing and Urban Development.
Right, and you can, if she's not going to fulfill that obligation, you as a tenant have a right to pursue her in civil court.
Okay, so I need that amount.
Well, then you need to contact her, and if she doesn't fulfill it, then you're gonna
I
probably...
need to contact her. It needs to be determined.
No, we don't determine that,
It
sir.
says.
No.
It says right
What
there.
I'm trying to,
This is the law.
did you call the information, the resources that we
Yes,
provided you?
I've called everybody.
Okay, and
Yeah.
what did they tell you?
I've been doing this for a week now.
I know, but did they provide you any guidance? Because I'm telling you right now,
Yes, that's how I found out about this.
right.
You weren't
But-
informed, they said?
No,
said no.
She was informed of her obligation. Again, we can't force her to do that. Just like she's asked you to not be.
Well, see,
Sir.
No, my turn.
She has been
My turn.
on.
I'm the one that came in here.
She's provided us information that you are breaking the terms of the permission to enter. You're there, the police have been called, you've been asked
Who
to
has
leave
been what?
after dark.
No, no.
Yeah, that's what
Let me
she-
show you. Got that too. She's locked me out. There's incident report.
Yes, no, she did tell us
Here's
that.
another incident report.
Right.
They were all harassing me.
Well, she said that you were playing loud music and she called the police. And she said that she did lock the gate
And
because she
the
was
police
concerned.
came,
Right.
okay?
But she said you're there,
And said I
and
have
she sent
every
video
right
of
to
you
be
there
there.
at dark time, which is not what you were given permission to do.
She what? She said
She
what?
provided photos and a video of you being at the location at
At
dark.
the location, I have a
At
lease
dark.
at the property. I have stuff there.
Right, but you're not allowed to enter the unit
And have not.
at dark time, and she
And
said
have
you were
not.
there at midnight and left did not leave until close to 2 a.m.
In the yard getting tools.
in the yard.
Yes.
Okay.
Not
She
in,
said
not
that you
in the
were
unit.
at the unit.
No, I actually have video, but I don't waste your time showing.
Right.
Every time I go there, I take the entire time I'm there. I have video of
Okay,
every
so my
time I've
question
been
to you
there.
is, what are your plans as far as when you think your stuff is gonna be gone? And when you're, because you did say you had somewhere else to sleep.
Well, see, I came down here looking for answers
Mhm.
for relocation. And
Okay.
nobody mentioned this. I mean, you're required by law to inform
Okay.
me of it. And
Well-
that didn't happen.
well-
I came down here searching aid, nobody mentioned it.
Well, we're not required by law to give you all of that information.
You
because
are.
It's determined.
It says.
We provide you resources, which in turn will provide you information on how your we don't have we don't give legal advice, sir. I can't sit here and tell
It's
you all
not
of your
legal advice.
legal rights.
It's not legal advice, okay? It's, you were to inform me about this law, that I should look into this.
Okay.
That's required by you.
And
179.75B.
that is your interpretation of that?
No, okay, let me hear your interpretation of 179.75.
Okay, so my question
Point
to you, sir,
one
what
B.
is it that you, what is it
What
that you
is
need
your
from us?
interpretation of this?
Sir, what is it that you need from us? What is it that you're here for today?
I need you to notify her.
But we've told her, excuse me, I'm gonna back up because
Okay.
you're in my personal space. I'm asking you, what else can we do today? Because I've already told you that we had this discussion with her from the very beginning, that what we're doing is completely separate from what she has the obligation to do for you as her tenant. Because for whatever reason, obviously she's decided to rent the unit out to you and you didn't have heat and that was your concern.
Right.
We said, and I told you that, I spoke with you the first time when you called, it's like the unfortunate part is that if we're aware of it and we know you don't have heat, it's technically you're not supposed to live in it. And so then we were supposed to come out for the courtesy inspection. That didn't happen. I didn't hear back from you.
Right.
And then we ended up hearing from the owner. And so at the end of the day, we told her that her obligation is to you as the landlord. And so she's fully aware of
You
what
told her about this law?
we've told her, well, I didn't give her specific laws because, again, as a landlord, she has an obligation to do that. She needs
Right.
to look into what her obligations are.
But you're required to tell her.
Just as a tenant, you have your obligations. It's not our job to tell you exactly what those obligations are.
You guys are required to tell her that she needs to pay for my relocation.
We've told her, but again,
You're also required to determine the amount
no.
she's to pay.
I'm gonna leave you out here for just a second. I'm gonna go back inside to talk with my colleague a little bit more about
Please.
this. But I will say that she was given that information, that she's required, and it was what we're doing is completely separate from what.
Here, let me trade you copies, because these are the things that I have questions about or
Okay.
need answers for.
Okay.
This means the entire section. But
Okay.
basically, why wasn't I informed? Why wasn't she informed?
She was informed. I just told you that like 4 times.
Why?
She was
She
informed.
wasn't informed if you didn't give her the amount.
No, we don't. No. Well, first of all, I haven't even seen a rental agreement.
It has nothing to
From
do with
either
the
one.
rental agreement, it's the fair market price.
Right, but it has to be based off the unit.
I would invite you to take a minute and read that.
Okay, sorry.
Thank you.
Now, I just want you guys to remember that she stated several times in this conversation that the homeowner / landlord had been notified.
So, we just, took a little time to consult with the city attorney,
Okay.
also the city manager, just to make sure that, I'm not missing anything as far as the interpretation and my understanding of our rule, and confirm that it is in fact a civil matter between you and the property owner. And so I strongly encourage you to take,
I understand that it's a civil matter. I understand that you're not going to collect for me. But you see, this provides me benefits in able to move and not be homeless. This law was written for me.
right, and that's why in a civil setting,
Right.
she will likely be, required to fulfill that obligation. We're
Absolutely.
just not the enforcement hand to make that happen.
But-
We can't enforce her to provide you relocation. We can advise her of her obligation as an owner, but
But
we can't make her do that.
You are required to inform both me and her.
We did.
You're required to determine the amount that will be paid.
Now, admittedly, I worded that incorrectly. What I should have said there was that the amount is determined by information made readily available by the Housing and Urban Development, HUD. It is delivered by the local agency to both the homeowner and the tenant. So they don't actually determine the amount, but they're required to tell you the amount.
No, sir.
It says,
No. If you look here, it says determined by the Department of Housing and Urban Development. This is basically like a code section that a jurisdiction would be able to use to determine that formula. However, we're not that proper jurisdiction. We're not a state courtroom, that would be determined like when you go to do a civil proceeding.
right,
These are like the codes and standards that they would abide by. We're not a court system. We're not established to work out this kind of formula and figuring that out between you and your landlord, because that would require documents and a process and
right.
they have landlord
That's what I'm
tenant
trying to make
resolution
clear.
situations.
She has 10 days to comply from the day you red tag. How
Right.
could she possibly do that if you're not giving her the amount to pay?
Because she would then, as an owner, have the obligation to figure out how. If she does not have the knowledge to do that, she would then need to seek someone who
figure
does
out is
and
to-
figure it out.
Look,
It would be a civil
the tenant-
proceeding.
okay, let me ask you this. Am I entitled to this?
I'm not an attorney. I can't tell you what your legal rights are.
The
These are
local
all
enforce-
codes that tell you that these are things that are available to you.
Right.
I don't know based on your circumstances and what
The
has happened.
local enforcement agency.
Right,
That
so your
would be
local
you.
enforcement would be the Contra Costa County Courts.
Now remember that she said that the local enforcement agency would be the court, because that's not true. They are the local enforcement agency, and later on that's spelled out very clearly
Courts.
and confirmed.
They're the enforcement agency?
Yes, because through
Okay.
a eviction process, through a civil matter, they would be the enforcement agent to make that owner, landlord, fulfill her obligations to her tenant, you. We don't have that capacity to do that.
In 10 days.
I don't know the realms of it because that's not something that, it's outside of our purview to even be able to make that determination. That would be the court's determination, the
What would
judge,
be, determine what?
what her obligation is. Look over your rental agreement.
She's obligated to pay me within 10 days.
According to what you're reading, but I'm not the court. I don't have that, I'm not interpreting that. That would be
But
for
I
attorneys
mean-
or a resolution, like a mediation.
How could she possibly pay me in 10 days
I don't know.
if you weren't responsible for
How does
notifying
making us
me?
responsible all of a sudden make money appear in the account though too?
It doesn't, I get
Okay.
that. But let's say she's got pockets full of money and can pay me. How possibly would she do that in a 10-day time period that's required by law if you weren't giving her the amount to pay?
I still
They
am
did-
confused as to why that computes. Just like, there's no difference than if you were to walk into PD, who does health and safety code is their Bible, not ours, and you walk into PD and say you need to give her a number, and they say we can't. It's not something that we have the capacity to do.
You don't have fair market price for our area?
No, we don't, that's not, we don't use that this is outside of our, we don't determine that. Like, that would be something for the courts to determine. These are things that they use to figure out formulas on what you're rightfully entitled to. I mean, what would be your fair market, I don't know how would I determine what a fair market rent value would be for an unpermitted shed?
I can answer that. That's an easy one. You go to HUD's website and you go to their fair market rent documentation system. You enter the zip code for the property and bingo, there's the fair market rent price. Mine just happened to be $1,934. Took me about
That's been
2,
read
maybe
now.
3 minutes.
Sorry, I don't, that's outside of my
Well, it has
knowledge.
nothing to do with the rent I'm paying, it's fair market price for the area.
Right, but I'm sure there's more that's involved in that.
Which, again, goes back to, we wouldn't be the ones, here we are, like, going back and forth about
Right.
what even are we looking at fair market value of?
Right.
Because it's
A
not,
house,
it's
a
for
room?
code enforcement.
For the record, I'm not a building inspector, but it was pretty straightforward. It's determined by the number of bedrooms in the unit, and a studio is considered a one bedroom, and has is a 1-bedroom, and then on up, how many bedrooms are there? It's not rocket
Yeah,
science.
that is outside of what we
Right.
used to do.
So the other thing is, have you contacted HUD? Because I know they specifically call out HUD here. Have you contacted HUD yet?
I have contacted HUD.
Okay.
And left my name and phone number
Okay, okay.
as far as it got.
So that might be somebody who's a better source, since it is something that they deal with more directly than we do. We're specifically dealing with the building code violations and the safety.
Are you
hazards
recording this,
therein.
by the way?
Yes.
I would ask that you stop, please.
This is a public office. I have every right to record everything. Every right. The First Amendment right.
Okay. Well, I think we've made it clear where we stand. Again, these are things that she may be required to do. But unfortunately, even though things are required of people, they don't always do them. So the court system would be more of what you would need to make her fulfill her obligations. Because we unfortunately just don't have the capacity to do that.
Well, the thing is, if she fulfilled her obligation, there'd be no reason to go to court.
Unfortunately, that's where my battery cut out, my phone died, but that was pretty much the end of the meeting anyway. So basically, they were saying the court was responsible for all this. And so I went back and did some more digging, and this time I went to the law library and got the entire code book, California Health and Safety Code, and just a couple of articles ahead of that article was a full explanation of the definitions of the enforcement agencies and who that was. Section 17960.1 reads, for purposes of this section, enforcement agency means the building department or building division of a local agency. 17960.1E Part 3 reads, local agency means a city, county, or city and county, which is who was denying they were responsible the entire time. So I decide, after finding this, to head back and show it to them. Partially because I knew I was right, and partially because I wanted them to be educated on this for the next person that comes along in the same situation as me.
Okay, I apologize for the delay. I still have to get this for you as usual.
Okay.
So I had to review the case real quick and then talk to the city manager, because at this point, after the 2-week window, they typically limit the hours to go in.
Right.
So I wanted to kind of get your feedback. We're talking about a 2-hour window each day to go in.
Right.
And I want to know what would be the best time
That's all
for
I've
you.
got now anyway.
Yeah.
Because I have to work
So
during
I want to
the day.
make sure I give you the appropriate time frame, though, that reflects your schedule then. Like, is it a 8 to 10 would be a bit best? Obviously, it's during daylight
It
hours.
would be at the end of the day.
Okay, so,
But let me just show you something that, this was week 1.
the calls.
The calls,
Mhm.
yes. So every time I go there, I have to wait for an officer to show up,
Okay,
and now she started doing lockouts.
okay.
And
Is
she
she
cut
blocking
power.
the gate or the,
Yeah,
okay.
so I can't access it. So I have to call, which I feel like an idiot even calling, because you can see the calls that they've dealt with already.
Yeah,
And, they're so fed up, the police department, that
Sure.
I had a police officer on day before yesterday, or maybe one more day, but basically refused to come give me civil assist
oh geez,
when I was locked out. And he ended up calling me back, and after he had kind of gone over the case more,
Mhm.
because I called for civil assist at 5:30 in the morning, because I wanted him to be there by the time daylight was, so I could have half an hour to an hour to come
Before
and back.
work.
Yeah.
yeah.
So that's neither here nor there.
So that's, but I appreciate you giving it, because that is good for us to know
Yeah,
what's going on as
yeah.
well. Would like a 3 to 5 work, or 4 to 6? I feel like after 6 you start pushing it for daylight.
Yeah, at 5 it starts,
Okay.
really. I mean, so yeah, 3 to 5.
3 to 5,
Yeah.
okay. And then, obviously we can change that as well.
Okay.
I'll make that through the week, well, I'll make it through Monday, just like
Okay.
this one, so that you have Monday to contact us. You also don't have to come in.
Right.
If you call me and say, hey, I mean, provided do you have a good email address?
I do, yeah.
Okay, I'd be happy to email it to you in the future, just because if you are working, I don't want you to feel like
Right.
now it's take time off to come into the city.
Right.
Or God forbid we're out on the,
Right.
and we miss you. So let me go ahead and get your new permission to enter, and then I believe you have our card. Do you still have our card?
I do, yeah.
You're really well organized. That's a
And then,
question.
I mean, I wanted to go over just, this is here or there at this point, but just for clarification, we talked about the safety code that I brought in, and this is your copy if you want. I just wanted to go, it's easier for me to go over it, you know, if you have a copy in front of you. I went and at the law library and looked at the entire California Code of Health and Safety, and because before I was just pulling information from the internet.
Sure.
So when you back up to Article 1, enforcement agencies, they outline the enforcement agencies, and what is it, 17960.1, Section E, number 1, enforcement agency means building department or building division of the local agency. That would be this agency, right?
It wouldn't be me specifically, since I'm code enforcement, I'm not
Right.
under building.
No, I mean, it would be building
Yeah.
for City of Oakley, right?
I would think so.
Yeah.
I can tell you that after you left last week, I did reach out to my counterparts in some other cities to try and see what they do, to see if there's some
I'm
discrepancy.
so glad you said that. Because I pulled, did I bring them? I pulled, yeah, I do. Here's one. I mean, the ones that I could find online. Diamond Bar does it, and there's, I don't know if people want to look at that, they do.
Well, I think the big thing is that, I've been talking to like our neighboring cities, since we're all under the same county and similar enough
Right.
rules in
That,
general.
I tried to find stuff from Antioch, but
Yeah.
there's just nothing.
And that's exactly what I'm running into as well. Also, I spoke with a couple of my counterparts and said, like, I can read your code, but what I'm asking for is, like, how does it actually look like in practice?
Right, how does it play out?
Yeah. Is it that we need to be putting the code section on the notice that goes to you in the
Right.
other one, and that's it? Like, what do we do? How does it
That's what I've seen is that they just put it in the notice and order.
And then the follow-through, it doesn't, so I'm still not sure if that's the case.
Right.
What I've been told from our neighboring cities, I was actually a little very surprised, was, it's not that common that they have occupied substandard housing. So my guess and my understanding is now I'm trying to follow up with their building departments versus their code
Right.
enforcement, and see how exactly they handle it, because
Right.
it sounds like they take more of the reins, whereas here code enforcement takes more of the
Right.
reins. And again, I have reached out to the city attorney as well,
Right.
to try and get some clarification for that. And I know it doesn't help you in your situation now, but I really appreciate that you've done your research, and then you've brought in things for us
Right.
to look at as well. Because if there is a gap, or if there's a way we can or should or have to be doing it differently,
Right.
then I absolutely want to be on
So
board.
then, because I was kind of unsure when I left last time, so she was never, meaning the homeowner,
Okay.
was never made aware of this when she was given documentation for the, I mean, it's not
It's
in
not
her
on the
order.
documentation,
Right.
correct.
She was informed of her obligation.
She was informed of her obligation. She was informed of her obligation. She was informed of her obligation.
But you're required to inform her of that.
Well, we haven't told her that.
But you're required to inform her of that.
Well, we haven't told her that.
But you're required to inform her of that.
Well, we haven't told her that.
But you're required to inform her of that. Well, we haven't told her that.
Okay, and I was never made aware of it, you know, So I guess we're done with that. I just wanted to go over that, but
Well, and
but
I
you're
appreciate it.
already on board with that, so I understand that.
Yeah, absolutely.
Is there any documentation, because I didn't receive anything
Okay,
for my order to leave?
for the red tag?
Yeah,
Okay.
I mean, other than the tag on the door,
Okay.
which can't be removed. I mean,
Sure.
I have no documentation at all.
Why don't I go ahead and print out a red tag for you, for your
Okay.
records? And then there's, typically, and I apologize, it's not my case, so it should
No, I
have a
understand.
corresponding notice of violation with it, that the owner and typically the occupant has provided.
Right.
So let me go get those.
Okay, great.
I know I have to reprint the red tag.
So they,
That'll take a couple
just to be clear, they didn't mail me anything that she may have withheld or,
I don't think so.
okay,
So typically what I like to do when I go out is I take it and I take a copy for the homeowner and a copy for the occupant. In the event that either aren't there, then we post them.
right,
At the very least, we typically post the occupant notice, and then the owner one can be mailed, because our legal requirement is to mail it. Obviously, you as the occupant of the rear structure, I wouldn't be confident knowing that you got the notice.
Right, exactly,
So,
yeah.
exactly. So let me go reprint. I apologize that for whatever reason you weren't provided that to begin with. And I will be right back. Oh,
Okay.
and let me get this as well. So I owe you a red tag, the notice of
And just the
violation.
letter, that's it.
And the letter.
Okay.
Give me
Thank
a
you.
couple of minutes, sir.
Thank you, Beth, very helpful.
Don't get a picture, it's, oh, you can
Okay.
pictures, but the printer is backed up right now, so
Okay.
give me just a minute.
No problem.
Oh, and those were the two different notices.
Oh, they're different?
It's my understanding from, so the first one was before we actually saw the property. Let me double check.
Oh, mailed order, and then,
21st. Yeah, this was
hand
before we saw
delivered?
the property, after we had spoken with you, but then, we weren't able to get in touch with you. We weren't
Right.
sure if we were gonna do the red tag or how that was gonna work. So this was the first one.
okay,
This was the second one that I believe, was after after they actually visited the property.
oh, right, okay.
Okay?
Okay, great.
Just for kind of, to help keep it clear, it can be a little.
Thank you.
First, yep, I'll be right back. So, here is the permission to enter that we discussed. And it's good through next Monday.
Okay.
Again, you're welcome to either email me or come back in. This time is about perfect, because it's before we've gone out.
Right.
Once school traffic thins out, we do tend to take off, so,
I didn't realize you guys opened at 7:30.
Yeah, except, you know what, I'm in at about, sometimes I'm in at 7:30, but typically 8 I'm
Right.
in, and then she's in about 8:30.
Right, okay.
So, and then this one is a copy of the red tag. It is not signed because that's our building inspector, and he's
Uh-huh.
not here. So he
That's
signs the
fine.
one on your door, but,
I photographed that one anyway.
Perfect.
I was more interested in the letters.
that's what I
Okay,
figured.
okay, cool.
All right, wonderful.
Great, that's great. Thank you, Beth.
You're welcome. Take
And
care,
you've been
sir.
very helpful, thank you.
No problem. It's a tough situation, and,
Yeah.
and I appreciate you coming and trying to work with us as well.
Okay, have a good day, thank you.
So at any rate, it looks like the city of Oakley is going to move ahead and develop a protocol for notifying displaced tenants that they have relocation benefits when their property they're renting has been red tagged. So I hope this video helps others know their rights, and maybe even other cities realize that this law that's been out there for a while now, since 2005 in fact, exists, and that they are required by law to notify people. At any rate, just remember you don't have to be a lawyer to know the law and apply it. I'll see you guys on the next one. Vigilante, okay.